And Catherine, what do you think? Should we get going? All right.
I think so.
Well, a big welcome to everybody for joining this MCEA webinar. We're talking today about the Minnesota Supreme Court's decision issued yesterday in the permit to mine case on PolyMet. And we are celebrating a big win. Thanks for being here. The permit was sent back to the DNR and we're going to have a contested case hearing. So we're very excited about that. I'm Kevin Ruther. I'm the Chief Legal Officer at MCEA. And with me today are Catherine Hoffman, our CEO. Hi, Catherine.
Hello.
And the lead attorney in our PolyMet case that was issued yesterday, Ann Cohen. Hey, Ann.
Hello, welcome.
So thanks everybody for joining us. And especially I want to thank you if you're a donor, because we've been working on this case for a really long time, more than 15 years, and we wouldn't be where we are today without you and your support. So thank you for that. What we have planned today is about an hour long. We have an hour reserved, and we want to talk a little bit generally about PolyMet, give some of the background, and then really dive more deeply into the case that was challenging the permit to mine and the decision specifically that was issued yesterday. We want to reserve some time for your questions. And so at the bottom of your screen, you'll see that there's a Q&A box. You click on that, you can put questions in there, and I'll be monitoring that while we go. And so please, if you have questions for us, anything that comes up for you as we're talking or towards the end, we will definitely want to take some time and get to your questions. So I think maybe, Catherine, it would make sense to start with you giving us some of the background. Before Catherine became our CEO, maybe people don't know this, she was a staff attorney, and actually she was the lead attorney on PolyMet for many years. So is in a good position to give us some of the background on PolyMet and get people up to speed.
Yeah, in fact, I always thought, Kevin, that I would be the lawyer that took this case to the Supreme Court.
I know.
I was a little jealous of Ann, although I certainly could not have done a better job. She was awesome. So yeah, I started with the organization in 2010, and at that point, PolyMet was already a little into the environmental review or the early stages at that point. And one of the things we recognized early on that probably a lot of you know by now is that, you know, this was the first one. We've got iron mines, but we didn't have any copper nickel mines. And we've got some laws and rules here in Minnesota that only apply to the sulfide mines. So, you know, the agencies had never interpreted those laws or written permits for that kind of mine. The courts had certainly never interpreted them. So we knew that given that this was the first, we have to get this right. Because hot on the heels of PolyMet is, you know, you've all heard of twin metals, but there's a bunch more too that you probably haven't heard of. There's Teck and there's Tamarack Deposit. You know, there's a whole bunch of companies that have invested in exploration of copper sulfide minerals that are, you know, all eyes on PolyMet to figure out, hey, is this a good place to build a mine or not? So we knew that PolyMet was a big deal for that reason. And then we identified some big issues that you know, are still, I think, around today. First of all, you know, this type of mining has never been done safely. We really don't have good examples of clean copper nickel mining. Most of the sites, or even all, have hundreds of years of pollution that they're probably looking at. There aren't great strategies for dealing with that or kind of closing the site in a safe way. Oftentimes, taxpayers are on the hook. And those tailings dams that hold in the mine waste are unstable. And we see examples of those collapsing and causing terrible tragedies around the world. So early on, we identified a bunch of these issues. And, you know, I think the process was slow, in part because these laws were new and had never been interpreted before. But then in 2018, you know, sort of between like the week before the election and when Walz stepped into office, suddenly it was rush, rush, rush. And we saw DNR and PCA like rushing these permits through right at the end of the Dayton administration, and probably made some mistakes in there because of it, frankly. So those permits that were implemented in that time in late 2018 led to multiple appeals. So we've got appeals of the air permit, the Clean Water Act permit in both state court, and then a related one in federal court that Fond du Lac has. And then there are also federal challenges of the wetlands permit. So there's all these other cases going on that are, continue to be litigated separate from this permit to mine case that we're talking about today.
Yeah, good. Thanks for that background. So Anne, as Catherine mentioned, the permits that were under appeal and for the decision issued yesterday were the permit to mine and then the mine safety permit. Maybe you could explain to folks what those permits are even about.
Sure, thanks, Kevin. Yeah, so there were two permits, the permit to mine and the dam safety permit. Or actually the dam safety permit was more than one permit, but we'll just call it the dam safety permit for now. So the permit to mine authorizes PolyMet to, unsurprisingly, open and operate the mine. But more importantly, the permit to mine establishes the conditions for reclamation of the mine and its tailings basin after mining is done. So that is the primary purpose of the permit to mine, is to ensure that our natural resources are protected. And in this case, the permit to mine established conditions that DNR and PolyMet proposed to control acid mine drainage, which is the unique aspect of sulfide copper nickel mining. And so the permit to mine established the conditions under which PolyMet and the DNR assumed that they would control this aspect of this particular type of mine. But what it didn't do in this case, and you'll hear more about this later, is establish when that reclamation had to be completed. So the dam safety permit, again, allows PolyMet to build and operate the tailings basin dam that is supposed to hold back all this mine waste. And it's supposed to do that for an extended period of time, and in fact, an infinite and undefined period of time. So that's what the dam safety permit is supposed to do, keep us safe for so long as this waste is impounded behind that dam.
What were the main concerns that we had about these permits and about the conditions that DNR put in the permits?
One of our main concerns, which is the one that the Supreme Court focused on, was this use of a type of clay, sodium bentonite, a very small percentage of that clay mixed with tailings that PolyMet proposed to plaster over the dam itself and also the large beaches that form inside the tailings basin. And I'm not talking like a little beach here. I'm talking about hundreds of acres of beach. And this mixture of bentonite and tailings, which also is supposed to go on the bottom of the 900-acre pond, was supposed to keep air away from the tailings, because air and water and tailings are the necessary ingredients for acid mine drainage. So that was one of our main concerns. Would this bentonite tailings mixture actually work? And did they have a system for actually laying it down over these beaches and mine faces that's tried and tested and existing available technology? So that was one of our main concerns.
Okay,
and another
and
one.
Let me just interrupt for a sec to get you to describe a little bit more about like how the tailings pond even works, or what the setup is, what tailings are. Just
Sure.
for folks who might be a little bit new to this.
Absolutely. So the tailings are, when they mine the ore, and this is true for our iron mines here in Minnesota as well as this mine, they take the ore and they grind it up, and then they put it through a wet flotation process using various chemicals that cause the valuable minerals to float up and off, and they collect those and they make a concentrate. But then you have this fine, powdery, ground up rock that's not economic. It still has a little bit of the sulfide in it, but they've gotten what they can out of it, and then they have to do something with it because it's a waste.
And that's
so what
tailings.
They do is they slurry that waste into a basin that's called a tailings basin. And in this case, we're talking about a 900-acre pond that's going to be 250 feet up in the air, because that's how far it will build up as time passes. that has to be dammed and maintained in this case for an indefinite period of time.
Okay. So the bentonite layer is on the sides and the bottom of that pond to prevent leakage and interaction with oxygen and water.
Correct, correct. So the pond itself is supposed to keep air away from the tailings, but of course the pond isn't over the entirety of the surface of this tailings basin. There are these large beaches, and then there's the dam itself, which is also built about on the tailings and with the tailings, and it all needed to be covered with this bentonite tailings mixture.
And what about the dam safety? Can you talk a little bit about the concerns there?
Sure. So the dam safety permit, the main concern was that DNR was allowing PolyMet to construct the dam using the slurried tailings themselves as foundation material for the next section going up of the dam. And this is called upstream construction, because as you let the tailings settle and you build the dam on it, the dam tends to walk toward the inside of the basin. So it's upstream, not downstream. This method has been banned in 4 separate mining countries and is considered widely undisputed the least safe method of building a waste dam to control, to prevent the waste from getting loose and catastrophically failing. These dams are known to suffer from liquefaction events such as happened in Brazil, and the design of this dam is very similar to the design that was used in Brazil.
Concerning. So those are a couple of the big issues that we've been expressing concern about for a long time, actually. Catherine, maybe we can go back to you. The EIS in this case went through a couple of iterations and you worked on those. How different are the issues today from what we were seeing, back in 2010?
Yeah, I mean, remarkably not very different. I remember recruiting experts and drafting comments on these issues. There was a supplemental draft EIS in 2013, 2014. We wrote hundreds of pages on it, and these issues were the focus of it. I think sometimes people accuse us of being, anti-mining, and we're really not anti-mining. We have serious concerns about this type of mining, but we're not just sort of grabbing on to whatever issue comes up. I mean, the concerns that we've expressed from the beginning are major concerns, and they have never been addressed. At times that agencies have tried to use that against us and say, oh, well, you already made this argument back in 2014. And we say, yeah, and you still haven't dealt with it.
Yeah. Okay, well, let's turn a little bit to the decision itself. And maybe I can just explain how we got to the Supreme Court quickly. So as Catherine mentioned, back in 2018, these permits were issued by the Dayton administration. We had commented prior to the issuance of the permits, and one of our comments was to actually request what's called a contested case hearing. It's sort of like a trial. Well, it is a trial in front of an administrative law judge, an independent fact finder. And that request had been denied. And then DNR went ahead and issued these 2 permits that we're talking about today. And we appealed those to the Court of Appeals. And last year we got a great decision from the Court of Appeals that said that DNR was in error when it denied our contested case request. And it also found that DNR's lack of a fixed permit term, a fixed term in the permit, didn't comply with the law. So what DNR has issued is this permit that basically goes in perpetuity, and we said that the law requires a fixed term. You have to have a date by which everything is going to be reclaimed. And the Court of Appeals agreed with us. So that decision then got appealed by PolyMet and the DNR to the Supreme Court. The Supreme Court agreed to hear the case. And that is what we're going to talk about now. So Anne, maybe you can describe what the court did yesterday in its decision.
Well, as Kevin said, there were 2 main issues. One was this contested case hearing and one was this term issue. And those were the only two issues that were appealed by PolyMet and the DNR to the Minnesota Supreme Court. So starting with the contested case issue, one of the things that DNR had decided was that as an organization, we did not have the right to ask for a contested case hearing because we were not our members were not affected property owners. And the Supreme Court decided against DNR on this. So this is a big win for us in the future if we want to ask for a contested case in another case involving a mine. The Supreme Court decided we do have standing as an organization based on our members who own property near the mine to ask for a contested case hearing. So that is a big win for us.
I want to interject right there, Anne, because we had a question kind of related to this. Was what, if anything, in this ruling provides useful precedent for future fights? And I think that this is a big one that you just identified.
That's exactly right. This is a big one. We can ask for a contested case hearing as organizations, as long as we can show that we have some members who are, can reasonably attest that they have concerns about the mine affecting their property. So that's really a significant win for us. The other thing that the court decided was that DNR does have the discretion to deny a contested case hearing, even if we show there's a material issue of disputed fact. So, that aspect went against what we argued, but the court then tempered that holding by saying that DNR's decision, even though it's within its discretion to deny a contested case hearing, is not something that has unlimited discretion. DNR has to show when it decides not to grant a contested case hearing that there is substantial evidence in support of its decision. So although we would have preferred a decision from the court that if there's a material disputed issue of fact and we're ready to move forward with a hearing, the DNR should grant that hearing. That would have been our preferred outcome, but this ain't bad because DNR still has to show when it denies a contested case hearing that that decision has evidence behind it. And in this case, the court decided here that DNR in fact did not have substantial information with regard to its plan to take this bentonite clay and mix it with tailings and plaster it over the tailings basin. DNR did not have substantial evidence for that, and therefore, I think it's a very difficult thing for a court to do. The Supreme Court ordered DNR to host a contested case hearing on that issue, but leaving it open for DNR to add other issues as it sees fit. So, that's the basic holdings on the contested case. And then, of course, the other issue that Kevin mentioned was the fixed term. And we had argued in comments and at the Court of Appeals that DNR could not issue a forever permit. It must tell the people of the state of Minnesota when the natural resources are going to be restored, when reclamation will be done. It must therefore establish a fixed term, a year, give us a time. And DNR had refused to do this, so it lost on that issue.
We have a question
Minnesota
about
Supreme Court said it needed to do that.
We have a question about that too, Anne. Sorry to interrupt, but my understanding is that that's an issue for the permit to mine, not so much for the dam safety permit. Is that right?
Correct. I mean, ironically, DNR said it couldn't establish a permit for the permit term for the permit to mine, but in the same breath, it did establish a permit term for the permit for the dam safety permit. So DNR was clearly acting in an arbitrary manner.
All right. Good. Any other issues that you wanted to mention there?
I would just note that the Supreme Court seemed very careful to note that it is within DNR's authority to address other issues other than the bentonite that were raised in this appeal regarding the legal sufficiency of these permits. And so although the hearing is ordered on the bentonite, it might be more than that. In fact, we hope it will be more than that. And the court specifically said that if DNR chooses not to address the issues raised by this appeal regarding the legal sufficiency of the permit, we may renew our challenges in a future case. So, so that is also a very positive thing for us. One thing that's kind of confusing is the Supreme Court decided that the Court of Appeals had prematurely reversed the dam safety permits, but noted that DNR could modify the permits after the contested case hearing if reconsideration is necessary. And because the dam safety permits specifically reference the bentonite issue, I think that's probably what DNR is going to have to do, but that's something we're discussing with our allies to figure out what exactly this means and what we should do about it.
Yeah, I mean, there's no question that it's a complicated case and there are a few questions left unanswered.
Absolutely.
Well, one thing, and Catherine, maybe I'll ask you this, you know, we're celebrating because this for us is a huge win. But apparently, at least according to their public statements, PolyMet is celebrating as well. I wrote down the quote from John Cherry, the president of PolyMet, who says, "This is a big win for PolyMet, our supporters, and for industry in Minnesota." So what's going on with that? I think people could be understandably a little bit confused. And a lot of the media reports have said both sides are claiming victory here.
Yeah, it is confusing, and PolyMet has, I think, successfully confused some of the reporters. You're getting some of this like he said, she said stuff. But I mean, a win for PolyMet realistically would be they have a permit and they get to move forward with their mine. They don't have a permit. We don't know when or if they'll have a permit again, and they can't move forward with their mine. So it seems pretty clear that's not an outright win by any means. You know, at a minimum, this decision will result in at least a year, probably more, of further delay. And that might also affect some of these other legal challenges and other permits that are waiting to be decided. You know, that's a problem for PolyMet to have to go through these additional hearings and time. And, you know, I think it's worth noting that although the Supreme Court narrowed the hearing issues a little bit from what the Court of Appeals had done, you know, the issues that are still there are big ones for PolyMet. So the DNR relied pretty heavily on this bentonite scheme as a way to meet some of the regulatory requirements. And the court said, you know, you don't have anything. There are no studies here. There's nothing in the record. You know, apparently PolyMet told some of the press yesterday that they do have some studies, but they're just, I mean, if they have studies, why wouldn't they have put those into the record over the past 16 years when it actually mattered? Like, I don't think that's a particularly plausible explanation. So, you know, how they're going to actually respond to this is, I think, a big question and puts a pretty significant hurdle ahead of this mining operation.
Thanks. So Anne, we know that there are some unanswered questions and it's complicated, but what do you think is likely to happen next?
Well, I'd say the ball is in DNR's court, right? I mean, the ball is in DNR's court. DNR, and really not PolyMet, but DNR will need to decide what happens next, whether it decides to go to this hearing that the court has ordered, or whether instead it wants to make changes to the current permits, take this opportunity, for example, to decide whether to add Glencore as a permittee or change the requirements for how the dam is constructed. This is the time when DNR really needs to act thoughtfully about what it wants to do next. And really it's DNR's decision. Now, of course, PolyMet or Glencore could just decide to walk away and mothball this project. So I can't say that won't happen. But as far as the legal case is concerned, the ball is in DNR's court, and we will be preparing for a contested case hearing on bentonite at least. And we will be looking and exploring ways to try to persuade either through the administrative process or actually just by the power of persuasion and reasonableness to get DNR to open this hearing up to other issues that are super important and critical for protection of the people of the state of Minnesota and clean water.
Yeah, we don't yet have a sense for really the timing, but what are going to be some of the milestones in, getting all of this underway?
Well, the milestone, the first, formal step will be DNR issuing what's called a notice and order for hearing. And that is what formally starts this administrative trial, which is held at the Office of Administrative Hearings in front of a neutral administrative law judge. So the notice and order for hearing starts that process. And then the case will proceed under the rules that govern contested case hearings, and we could have a period of discovery in which we get information from each other, and we can ask interrogatories, which is a fancy lawyer way of saying questions that have to be answered on the record, and we can ask the parties for admissions, etc. We will probably also be asking DNR to produce whatever information it has using the Data Practices Act or other existing tools. Mm-hmm. And so anyway, so that's the way this will start with the notice and order for hearing, and then it will go from there until finally we have a trial with witnesses and cross-examinations and experts, and the ALJ, the administrative law judge, will then compile the record and make a recommendation. Not a decision, but a recommendation back to the department about what to do.
So this trial could involve many, many experts, right? I mean, DNR will have experts, PolyMet will have experts, we will have our own experts, and other intervening parties who are interested in this may have witnesses as well. So we could be talking about a fairly significant trial.
Right. I would go out on a limb and say weeks.
Catherine, what did you want to say?
Well, and more than that, I mean, it gets quite expensive, right? Because the experts are expensive, and then they charge more for the testimony typically, because nobody likes to be cross-examined, so the hourly rate goes up. And we have quite a few lawyers involved, paralegals, support staff, all that stuff. So it gets quite expensive. I will note that MCEA has a fair amount of experience with these contested case hearings, even though DNR is very reluctant to order them, except if the mining company asks for them, actually. But over at the Public Utilities Commission, it's fairly common for some of the proposals from the utilities to go to contested case hearings and administrative law judges. So the procedures, processes are things that we've done before and can get quite extensive.
Yeah, good point. So Catherine, what can people do if they want to kind of continue to be involved in this fight right now?
Yeah, I mean, there's a couple things. I mean, one is that, we will be talking to our supporters about asks to the governor and to his DNR moving forward. I mean, this issue has been in the courts for a long time, and obviously some of the permits are still in the courts, but this particular permit is now back, squarely in Walz's court. So we will be talking to you about how we can ask Governor Walz and the agencies to do a better job this time around than the previous administration did. So make sure you're signed up for our action alerts. You can do that at our website. That's really important. The second thing is, and most importantly, this work takes money. The Supreme Court has ordered this contested case hearing. As Anne mentioned, it's reserved some of our legal challenges for later litigation and said, okay, we'll listen to those arguments later. MCEA is committed to fighting this thing, and with your help, we can win. And we have quite a few sort of arrows left in our quiver, legally speaking, but we can only use them if we have the support and the capacity to do it. Every brief that we put into the court takes, hundreds of hours of experts, hundreds of hours of review by support staff, paralegals, folks like that, and certainly well over 100 hours of work by our attorneys. So I do have a specific ask of all of you who have joined us today. My ask is that you pledge to become a sustainer at $100 a month. We are a great deal, by the way. Like you're getting a lot of bang for your buck here. PolyMet and DNR's lawyers are making, $400, $500, $600 an hour. We're not making that. We're asking for a lot less. So you can get great lawyers at bargain rates to protect your clean water, but we do need your help. And the sustainers committing to do the monthly donation, those are reliable, committed donors that we know will be with us through this fight. Really helps us make those investments that we need to make to be ready for what's coming next. This has been a big milestone with the court, and that's great. I think it's proof that our strategy is sound and that we're pursuing the right strategies here, but it's definitely not over. So please go ahead and there's a link in the chat. Go ahead and make that pledge of $100 a month and stay with us.
Thanks. We're getting a lot of really good questions here. I will encourage you to put your questions in the QA box at the bottom of your screen. So let me just turn to some of those. Somebody asks, what is bentonite and where does it come from? How is it supposed to work? We don't have any engineers on the line today, but Anne, can you take that one?
Yeah, I'll try to practice science without a license and answer that question. So bentonite, just simply is a clay. I mean, clay like you would go into the pottery studio and throw a pot, that slippery, firm stuff, which, in the upper Midwest, frankly, we have a lot of clay in our naturally occurring soils, huge layers of it. But it comes in different types, and sodium bentonite is one type of clay. There are other types of clay, and basically clay molecules tend to band together in the presence of water and form a firm layer that reduces the ability of water to penetrate through. So clay is often used to seal things up in an appropriate thick layer. But what's novel here, and the reason why we're really concerned about this bentonite plan, is this is not a nice thick layer of engineered clay. Instead, what PolyMet is proposing to do, which is an untried technique, is mix a little tiny percentage of bentonite clay, probably in a powdered form, with a great big bunch of tailings. So 3% bentonite, because they don't want to pay for more, with the rest being, 97% tailings. And they're hoping that the bentonite clay will create a nice seal within that layer. And our experts, and frankly, DNR's experts and DNR staff, all questioned whether that would in fact work. Hopefully that's enough of a science explanation. If you want more, I think Kevin's right. You're going to have to call in an engineer.
That's pretty good for a lawyer. There's a question here, Catherine, that maybe you can answer, suggesting that we refer to Mount Poly quite a bit. What happened at Mount Poly? Is it similar to what's proposed here? Why is that relevant?
Yeah, so Mount Poly was a Canadian mine where there was a tailings dam collapse. And the tailings dam, as Anne has described, is the dam around the outside of the facility, and then inside's a bunch of mixture of the mine waste and water. So it's pretty wet. And it will, if the tailings dam collapses, then all of that stuff spills out because there's enough water in there that it acts like a liquid, essentially. And at Mount Poly, they had, built the tailings dam up and up. And in fact, they had built it, a little higher than the original plans, I think, had called for. And then at one point, it simply had this what's called a liquefaction event, which is as bad as it sounds. It just means that what was solid is now liquid. The dam collapsed and everything spilled out into this nearby river, which hosted a really fantastic salmon fishery. A lot of businesses depended on it, as well as some tribes. And in the wake of it, what was interesting is there was an independent panel that investigated this collapse. And one of the things they said is, look, the best practice is not to have any more of these dams. Because although there were some problems at the Mount Poly Dam, it's not at all clear that even with the best practices and even with regular inspections and all that, that they would have actually caught the problem. There are problems with these mines that are really difficult, or with these dams that are difficult, if not impossible to detect. And then catastrophes happen anyway. So they basically said, don't do this anymore. Our recommendation for best practices is to store the mine waste as dry as you can. Even if it's not completely dry, at least not in this like liquid state where it can, flow out into the nearby lakes and rivers. And so that's been, something we've pointed to is, hey, we have more information about what the best practices are for safety at these mines, and PolyMet's not following them. They're following the exact same strategy that was used at Mount Poly.
Great. We have a follow-up question for the attorney engineer on bentonite. Sorry, Ann. But I wanted to have you describe the answer to this one. So this person is wondering, where will they put the bentonite clay mixture? Will it line the bottom of the tailings pond? And if so, how does it get there? Isn't there water, et cetera, in the pond now? Yeah, the description of how it's going to get there is a good one. So
I so wish I could show you a picture of this because it would make you laugh. So to get the bentonite onto the bottom of the 900-acre pond, PolyMet is proposing to have a radio-controlled barge, so an unmanned, I think, barge that will go back and forth across this tailings basin pond, dribbling the bentonite out the back or rolling it off a roll out the back, and hopefully the bentonite will filter down through the water, the polluted water, I might add, and get to the bottom of the basin and seal it off. And literally, PolyMet shows this little barge with a little Sputnik-looking thing on top of it, with a little circle showing its radio control. All of the experts said that would not work.
It's as dumb as it sounds.
It is absolutely as dumb as it sounds. The little 900 acres. I don't know whether you guys have a sense of how big 900 acres is.
That's another question, actually. Do we know how many square miles that is?
I know how many Lake Comos that is. So hopefully everybody's been to Lake Como and St. Paul and you've walked around it. It takes about 40 minutes or so to walk around it. Well, we're talking 17 or 18 Lake Comos worth of water.
Wow.
Big. Yeah, very big. Catherine, you addressed this a little bit, but maybe you can again. What authority does the Walz administration have over the future of PolyMet, if they're one of our targets?
A lot of authority. Yeah, so, one of the things that is both the kind of is both good and bad, I guess, about our laws in some way is that the agencies have a fair amount of discretion over how they regulate these mines. We often hear this, statement about how we have the best environmental laws in the world, and Minnesota, we love to think we're better, Minnesota exceptionalism and whatever. And I mean, we do have good laws in some areas, like we have the Minnesota Environmental Rights Act, the Minnesota Environmental Policy Act. Mining is not that area. Like, our mining laws are weak. Brazil and some Central and South American countries have better mining laws. Canada has better mining laws in some aspects. Montana does. Like, these places have learned from their problems and have done better. And we have never had the chance to learn, really, and we apparently aren't learning from their experiences either. And so we have these pretty weak laws. And in general, what happened with the previous administration, the Day administration, is they took like kind of the bare minimum approach on everything. And so, you know, for example, in our air permit case, we asked them to investigate whether PolyMet was going to actually build a bigger mine, because they were sort of saying that to their investors. And they said, no, we don't have to do that. And everybody agreed they could have. But they wanted to take that all the way to the Minnesota Supreme Court, that they didn't have to, and we can't make them. And so they were really setting the bar pretty low. And with the discretion cuts the other way too, right? So an administration that wants to interpret some of these laws more strictly, that wants to engage in some of these questions and really ask good questions about, hey, what are the risks of this mine and is it worth it to the state of Minnesota? They have that authority too. So the Walz administration could definitely do better, even with the laws that we have. And that's a choice that, you know, is yet before them, because until this moment, everything's been in the courts. And this is the first time it's back really in the agency's decision.
Yeah, really great points. Going back to the contested case hearing, and we have a question about what constraints are on the DNR once it gets a recommendation back from the administrative law judge after the whole trial.
This is a very good question. So the administrative law judge, as I said, does not decide the case. The administrative law judge will pull together the record and pull together some findings and pull together a recommendation, which will be sent to the agency. And then the agency itself has to make the final decision on what it wants to do. And if it doesn't want to do what the ALJ recommends, it is free to change the findings based on the record and change the conclusion and do what the agency wants to do. But, and here comes the but, when this case gets appealed, if the agency has not followed the recommendation of the administrative law judge, it has somewhat of a harder battle to persuade the Court of Appeals that it has not acted in an arbitrary and capricious manner. So going against an ALJ decision is possible, and you can win that case as an agency, but it is more challenging. So they'd have a headwind if the ALJ said one thing and the agency decided to do another.
All right. I'm getting so many questions here that I'm getting lost in all of them. They're great questions. I know that there's one that is talking about PolyMet's claim of its multiple wins. I think that they said that there were 10 claims in the case and they won on 8 of them. What is our response to that? Catherine?
Yeah, I think this strategy of spinning this decision is interesting. It's creative, you know. And if this were a tennis match or like a basketball game, like that might work. You know, all right, you got 8 points and you got 3 points and they won. But that's not at all how this works. And so I find it sort of comical. The question isn't, you know, who scored more points at the courts. The question is, you know, does PolyMet have a permit to mine and can they act on it? And the answer is no, they don't have a permit to mine and they can't act on it. And I think it's important to like look at, you know, the specific claims that were lost here by DNR and by PolyMet because they're really important. You know, we mentioned there's no evidence for this bentonite scheme. I mean, the court says, you have nothing. There's nothing in the record here is really what the court said. And so it's not just a matter of going back and have a hearing, right? I mean, they actually have to bring the evidence to show this works, and they do not have that evidence today. So are they going to conduct some studies? Are they going to totally change their mine plan? They're going to have to do something fairly drastic to deal with that. And the term one that they also lost is an even bigger deal in some ways, because and I think there's some confusion about this. The term of the permit to mine is not just like how long you're mining. So it's not just, you know, DNR inserts a date and says, great, we're done mining by 2050. it's not a clerical error that they forgot to put a date in, right? What the law actually says is the permit to mine is the term by which you finish mining, you reclaim the site, and you reintegrate it into the natural area. So they have to pick a date by which they will actually have taken the site and said, we're done. There's no further activity that's needed here. The problem is that we know from other copper nickel mines across the country and the world that those strategies are often not available. I mean, there are copper nickel sites in Montana where the state has just accepted that these are forever pollution sites, that they will have to have a wastewater treatment collection system and a wastewater treatment plant forever and ever, and they have no idea when or if they'll ever be able to close that. And the same problem exists for PolyMet. They don't have the technology today to say, yeah, we can close this mine and make it look, you know, more or less like it did before without constant maintenance to deal with the pollution. This pollution can last for hundreds of years, and that's in the court's decision. They talk about 200 years of pollution. So how is PolyMet going to deal with this if the technology doesn't exist today? So, you know, you can count up, you know, claims here or there, but that's sort of ignoring the substance of the real problems that PolyMet's going to run into in trying to deal with the deficiencies that the court identified.
So the 2 buckets we scored are worth a lot more.
Right.
There's a question. Yeah, they were more than 3-pointers, maybe.
Right.
And so one of our really important partners throughout this whole battle has been the Fond du Lac Band of Lake Superior, Chippewa. And they've played a really important role in fighting with PolyMet. So there's a question here, if you could just talk generally about what role they've played and how that's helped us out.
Well, the Fond du Lac Band has been an ally throughout this process, and they have special access to the state agencies, both I think as a matter of policy and as a matter of law. During the environmental review process, the state agencies were required to consult with primarily Fond du Lac, because it is downstream. Its homeland is downstream. Its reservation is downstream and will be affected by anything that goes wrong at the PolyMet mine. And so I'd say one of the most important contributions of Fond du Lac was resisting DNR's conclusions in the environmental impact statement and making sure the record was clear that it did not agree with those conclusions. And also they brought lawyers and they brought experts to the environmental review process and also to the court process. And we worked closely with their lawyers. Their lawyers did an excellent job and helped us extensively throughout the litigation. So they've been a great ally, and we truly hope they continue to be as active as they have been in this. And I should also acknowledge, and I think Kevin mentioned this, that they brought a separate case challenging the wetland destruction permit issued by the Army Corps of Engineers, and they have had success in that case. So that permit is now on hold as a result of their effort.
Yeah, that's a really big deal. Catherine, you will like this question. As you noted, it's going to cost us a lot of money to get through this contested hearing and continue this battle. And so someone asked, do you have a good ask letter we can send out to friends and families?
Yeah, so your invite to this webinar is a pretty good summary of the decision. And so that would definitely be a good thing to forward that email. But the ask, I think the best thing that people can do is get on our mailing list themselves. And maybe somebody can post that link in the chat to our, mystery MCEAers who are here. Go ahead and thank you. Yeah, go ahead and get on that list, because our alerts of when you can have an opportunity to, sign on to petitions or make direct asks of the governor, all that's going to go through that link, and that's where you'll see it. So that's the best place to do it. And of course, when they're on that list, they'll also receive, information about our events, and information about our fundraising and how they can support that as well.
Great. So I think that we should give a bit of a recap. There's a number of questions about the other permit appeals. So maybe we could just tick through kind of the status of those. So there is the air permit, which was decided a few weeks ago by the Minnesota Supreme Court. Anne, you want to tell us where that is at now?
Sure. So the air case actually built on a case that we had brought earlier and unfortunately lost at the Court of Appeals, asking for a supplement to the environmental impact statement on the basis of representations that PolyMet was making to its investors that signaled it intended to build a bigger or an accelerated mine. And this directly affected the air permit, because if you are applying to be a minor permit, which is what PolyMet was doing, but you intend to actually shortly after permitting change your permit status to major, that is considered to be a violation of the Clean Air Act. So we brought a case saying at the Court of Appeals, appealing the air permit that PCA issued, arguing that PCA needed to have taken a look at this issue of whether PolyMet intended to expand its facility, which is called sham permitting. And we won that case at the Court of Appeals largely because PCA failed to look at the issue. PCA just waved it off and tried to ignore us and bat us away. And the Court of Appeals said, not so fast, PCA. That went up to the Supreme Court. And the Supreme Court said, no, there is no obligation on the part of PCA under federal law to look at the sham permitting issue at the time of permitting, despite EPA guidance to that effect. But there might be state law requiring PCA to take a hard look at this issue. So right now we are in the Court of Appeals and have briefed the issue of whether state law requires PCA to take a look at an issue that a party puts in front of it before it issues a permit that might affect the eventual outcome of that permit. So we're waiting for the Court of Appeals decision. We'll get it in probably about 60, 70 days now. And we'll find out what the court thinks of that one.
So that's the air permit.
That's the air permit.
How about the NPDES, the Clean Water Act permit? Catherine, do you want to talk about that one?
Sure, I can talk about this one. So this is anytime you're going to discharge pollutants to waters, lakes or rivers under the Clean Water Act, you have to get a permit for that. And it's issued by the state, but also EPA has some oversight as well, because of course, Clean Water Act is federal law. And so PolyMet got their permit in 2018. And soon after that, there was this weird thing where the EPA didn't say anything about the permit. There was no comments from them, which was kind of weird because we know they'd been involved the whole time. And later it was leaked by some EPA, actually by the union that represents the EPA employees, that they did have comments. And they were going to send them in. And the state agency said, no, don't do that. Just read them over the phone. And so they had like this phone conference where EPA read their comments, maybe kind of fast over the phone. And then there were some state employees on, none of whom kept their notes for various reasons. And the whole thing was very shady.
Very unusual.
Yes, and very unusual. So we had a long district court hearing in January of 2020 that some of you might remember, a trial of sorts over this kind of narrow question of whether there were procedural irregularities, which is under the Administrative Procedures Act, the question you ask. And ultimately the judge said, no, there are not procedural irregularities, but there's, a lot of stuff came out in that hearing that made it clear that it wasn't great either. And so that went back up to the Court of Appeals, and then they just sort of stopped the whole thing because they said, you know what, none of this is going to matter if the permit to mine doesn't go forward, so we're just going to halt it. In the meantime, the one update on that was that last week, the EPA's own Office of Inspector General they did their own investigation into whether this process where EPA didn't comment in writing was followed EPA's procedures, and they concluded that no, it did not. EPA violated its own procedures in this case, and also relatedly to the wetlands permit, they didn't follow their procedures in relation to the Fond du Lac ban, that they should have given notice to the Fond du Lac ban that PolyMet might affect them, which would give the Fond du Lac ban some rights in terms of how that permit is issued in the process. So that report was issued last week, and the EPA sort of accepted the recommendations coming out of that. It's not totally clear what the next steps will be on the water permit. Now that the permit to mine is back at the agency, it's possible we'll see some, movement at the Court of Appeals to restart that litigation. But the merits of the question whether the water permit actually protects Minnesota's waters has never even gotten to that. All we've ever done is, was this process problematic?
Yeah, so we're waiting for a decision from the Court of Appeals on the air permit. That could lead to another appeal. We don't know what that decision is going to be or where it's going to go. The water permit, we're basically, we've never had a hearing on the merits yet. So at some point, assuming that PolyMet doesn't walk away, that's going to have to be argued. We also have a case in federal court challenging the wetland permit, the 404 permit. And right now, that is connected somewhat to the case that Anne mentioned that Fond du Lac just had a really good result in. And so that's been kind of put on ice for a bit, but that one will also be coming up in the future as well, likely if PolyMet continues to go forward. So we have really a lot of balls in the air, I think. And what's right before us today is going to be waiting for this contested case hearing notice and really getting prepared for it. Yeah, go ahead.
Kevin, there's one thing I want to add that I think is a good theme throughout this litigation is that a lot of there were definitely, the permit to mine, definitely there were issues that we raised from the get-go that are finally making it to court. But we also see in some circumstances, there's information that came out later only because of litigation. Like, in other words, if nobody had ever brought the legal challenges, we would probably never have known about all of the shenanigans between EPA and the state agencies over these comments that the EPA had and all of their concerns, which are pretty significant. Similarly with the air permit, that was really over information that PolyMet released like 10 days after the public comment period was over, when they said, here are our plans to build a bigger mine. And, they said, oh, it's just coincidence that we waited till the public comment period's over. And you can believe that if you want. But the fact that we have the litigation is the only reason we were able to force the agencies to actually reconsider that information and have the courts look at it. So I do think that there were definitely people who said in 2018, oh, they got the permits, this thing is over. And this is we have some pretty stark examples of why, having organizations like MCEA that are capable of gathering that new evidence and knowing what to do with it and how to put it in front of an agency properly and forcing the courts to ask these questions is super important, because otherwise none of this stuff would have come out.
Yeah, absolutely. So we're going to have to wrap this up. We're at our time, and we didn't get to all of your questions. Thank you for all the good questions today and for joining us. I just wanted to say before we close that in my role over the last 15 years here at MCEA, I've had pretty much a front row seat to see all of the work that's gone into getting us here today. And it's an incredible effort from a very dedicated and talented staff. Lawyers, legal assistants, analysts, experts, public relations people, lobbyists, community outreach folks. This case really, it's touched every single person in our office. And I just want to second Catherine's point that we couldn't have done this without you, our supporters and our donors. And we're not done yet. So I'm going to have my Kathy Wurzer moment also, and ask you to please dig deep and especially consider becoming a sustaining member at that $100 a month level. for upping your commitment so that we can continue this effort and put our best case forward. And as the supervisor of all this litigation, I just want to guarantee you that we will make good use of your support and your dollars. We will develop the best strategy, hire the best experts, and make the best arguments to protect Minnesotans, downstream communities, and our precious waters. So if you'd like to give, and I really urge you to do that, you can find a button at mncenter.org. If you have more questions for us at any point, feel free to reach out. Our emails are on our website also. Thanks so much for celebrating this big win with us today. It's a really important milestone for us, and thanks for being here.
Thank you.
Thank you, guys.